Well, joining us now is Arise analyst and lawyer Frank Tietie. Frank, good to see you. Having had that very fiery discussion yesterday, here we are today. Let's see what we can make of this Rivers situation. I mean, how ambiguous really is the 1999 Constitution on the issue of tenure of local government chairmen?
The Constitution is unambiguous. The Constitution is clear.
Right.
Section 7, subsection 1 expressly, establishes, provides for the existence of local government councils by democratically elected council members, not by the fiat of a governor, nor by even the law by the National Assembly, the House of Assembly. What the Constitution does, give to the House of Assembly is that it should make a law with regards to the composition, the establishment, the functions, and it's the members, what they should do.
Right.
It didn't mention tenure. However, in practice, and going by the various local government laws that have been made over the years, given since 1976 to date, the state government, the State House of Assembly has the power to determine the tenure. And across the country, it's flexible. There are some states where you have 2 years, others have 3 years, and there has been a clamor for 4 years. So it's express. What the Constitution presupposes is that at every material time, there must be a democratically elected group of persons who form the council government of a local government council in this country. There is absolutely no provision for caretaker committees. It is unknown to Nigerian law.
Like the governor is trying to
whatever it is, well, the governor has been smart not to use the word caretaker committee, but to say heads of the administration in the local government council should take over, which is also an attempt to, make nonsense of the Constitution. The reason is that the Constitution is very, very strict about it, and the Supreme Court has also emphasized it. At no point in time should the local government system, which is by democratically elected members of the council, should be prevented from existence. At every material time, the local government councils must be in place by persons, run by persons who are democratically elected. That is what the Constitution says. It's clear. Now, it also behoves, the responsibility behoves on those who man, especially the executive, given that is the president and governors, the affected governors, to ensure that at every point in time, whenever the tenures of council members of a local government, the tenure is about to expire, they must, according to Section 150 of the Electoral Act, together with the provisions of the Constitution, which allow state House of Assembly to make laws to get in recognition of the fact that there exists a state independent electoral commission to conduct elections, to fill those positions. So what we have here is a crisis of persons who have deliberately decided to disregard the provisions of the law. You will always find breakdown of peace and order when you disregard the law. So the contestation in Rivers State should be, what does the law say as a matter of fact? And you cannot benefit from your own wrong. I do not wish to support any group, but as governor, you can't be talking like a military man giving directives where you do not have the jurisdiction, where the Constitution does not give you that right to say, I direct, I do this, I do this. No, it's wrong. The governor should have been preoccupied.
Yeah, what really should be the role of the governor in this situation?
The role of the governor, is supposed to implement the law.
Right. And
he has an advisor in the person of the Attorney General of the state, who, to give him clear-cut direction as to what the law says. So not by circumventing the law. And, especially, the case of Rivers becomes a bit, interesting when you have a certain House of Assembly in place led by a particular speaker whose position now is said to be controversial because of conflicting court judgments and orders. However, that it's important that there can't be a vacuum. In the space of a vacuum, you must turn to a law that is not yet set aside.
Great. Now, there's an interesting point that's being raised here, and the question really simply is, can state assemblies extend tenure of governors under the guise of making laws for the state?
No, wait. You know, principally, when talking law, you talk about jurisdiction,
right,
which means the ground upon which any authority or persons can act according to law. Mm-hmm. In this case, are you referring to governors or local government council chairmen or councillors?
State governors, because if we say yes, indeed they can, by extension, you would say that the state assembly can actually extend the tenure of the local government.
No. You know, matters that are of federal nature.
Right.
The local government councils are not in any way of the same pedestal with state governments, because you see, even though it's difficult to appreciate and understand how states are federating units. Clearly, the Constitution matters that have to do with the amendment of the Constitution, are federal in nature and matters to be dealt with by the National Assembly. So in this case, we're talking about the powers that have been donated by the Constitution to the House of Assembly. The House of Assembly of a state, being given such powers under Section 7, subsection 1, to enact a law to govern the composition and establishment and the functions of a local government, together with the constitutional provisions, can indeed make a law to extend the tenure of local government council members. However, if that law in any way, if anybody perceives that law is contrary to any provision of the Constitution, that law will continue to remain in force until it is set aside by a court of competent jurisdiction. In this case, if ever the facts are true to the extent, and as they point out, without any contradiction, that there is a law that has been validly made by the Rivers State House of Assembly, extending the tenure of the local government council chairman or council members, that law remains valid and should be given effect
considering the circumstances of their, remaining as members of the state assembly.
That's a question of fact.
27 years.
No. Interesting. You're talking about the members whose position as to their defection is being contested in court.
Absolutely.
That's a different matter. That's a different matter. Because as at what time, what was their status when they enacted that law? That law was enacted validly to the extent that it was passed in the State House of Assembly and then, transmitted to the governor for his assent. The governor rejected, he didn't give assent, he didn't reject it, and then they also now, in compliance with the provisions of the Constitution, bypassed or overrode the assent of the governor. So it became law. So the governor would have done everything possible through his Attorney General to set aside that law. If that law was not set aside, the issue of whether or not the status of their membership is in contention does not arise.
Are you saying they passed that law before the issue of their defection came up at all in the first place?
As it was, they were the subsisting members of the Rivers State House of Assembly. There was no contention as to their position. However, I'm aware of a court order directing them, giving an injunction, stopping them from proceeding with that law. But they must have been advised by superior counsel that you cannot, as a court, stop the work of a House of Assembly. The same way you cannot oust the jurisdiction of a court cannot prevent the National Assembly or a State House Assembly from carrying out its constitutional function. However, they proceeded with enacting that law.
Okay, I'm trying to concentrate on what you're saying now while some questions are pouring in here. Very important questions, for that matter. Let me, get your thought on this. Once an election has taken place for a tenure, can any law extend it?
Which law? You see, we are talking, no, let's get one thing very clear. We operate a democracy that talks about, that exalts the rule of law. I would describe it as the supremacy of law. So long as there is a law, however illegal and however inconsistent it may be to another parent law, in this case the ground law, which is the Constitution, so long as the courts do not set it aside, it becomes valid to that extent. However, if there was a law that established, that defined the tenure of local government council chairman to be 3 years, and the same authority that created that law goes ahead to amend it in the case of Rivers State, by extending it, it becomes the law. It becomes the norm. So as we speak, if we limit these issues, if we drop politics and other intervening issues and limit it to the law, until that law made by the House of Assembly of Rivers State is set aside, it is a valid law.
Well,
and
the Rivers State High Court that set it aside actually said, look, it was not in tandem or inconsistent. It was inconsistent with the 1999 Constitution.
Well, the provisions of that, what the governor should be citing is the provision of the order of the court.
Right.
That nullified that law. As I speak, I am not aware. The provision, what I'm aware of is the provisions of a valid law that has been enacted by the Rivers State House of Assembly.
So where does all of this lead us? If the rule of law that really should be the guiding light here, on all sides, if the rule of law is set aside, what next?
So
because you see what's developing in Rivers State now. It's like a descent to anarchy.
When officers of the state, particularly the president and the governor, take the oath of office, they pledge to uphold at all times the provisions of the law.
That's right.
In this case, the governor, and I hate to appear as if one is on one side, but I proceed from the fact that to whom much is given, much is expected. In a democracy as ours, the president and the governor have executive powers, and they appear to have more responsibility in ensuring compliance to law. So in this case, if the governor had an ample opportunity to ensure that he complied with the process of ensuring that there is not necessarily a process, but a provision of the Constitution, that at every material time there should be a democratically elected council. The governor ought not to be on this process. He ought to have done that. Now, what is the governor trying to say? Is he trying to say that he prefers that there should be councils in Rivers State that are operated by persons who are not democratically elected? Is that what the governor prefers? To another law that is in contention, that provides that the persons who are elected, their tenure should be extended. So, you see, if you measure the value of this compliance to what the law says, I think the law made by the members of the House of Assembly is closer to the will of the Constitution,
so
as in Section 7.
If we allow this to fly or pass, are we saying that we can actually use this, apply this as a template? I asked you a question earlier. Can the National Assembly, actually the State Assembly in this case, extend the tenure of the governor? Can the National Assembly, extend the tenure of the president?
Yes, it can. Let me tell you this.
In what circumstances?
It has to follow the process of a constitutional amendment. The Constitution is very clear as to the tenure of the president and that of the governor. But the Constitution gives that kind of wide latitude to the State House of Assembly as to determining the composition and of the council, and the power to determine the composition extended to to determining the tenure of the council members. And if that same House of Assembly had said that it was 3 years, and they moved again to validly amend that law to extend it by 6 months, I think that is in compliance with the intention of the Constitution, particularly Section 7, subsection 1.
Is that what the 1999 Constitution envisaged?
Exactly. Because I've been mentioning Section 7, subsection 1.
Right.
That word, democratically elected, is tied to local government councils, the existence of local government councils. That is, if local government councils must exist, then it must be operated by democratically elected persons. That is what the governor has frustrated in Rivers State. However, what the contention therefore is, what are the facts? What is the law?
Yeah.
The law is until there is a clear-cut order of court, which you have just raised, which I'm not aware of. If there is an order setting aside that act of that particular provision as a result of inconsistency with subsection 1 of Section 7 of the Constitution, it will be a different matter. But as things stand, there was a validly enacted law by the Rivers State House of Assembly extending the tenures of those local government chairmen. If that law is not set aside, it means that those local government chairmen are still in office by virtue of that extension act of the House of Assembly.
Going forward, how do we fix this conundrum? Because there seems to be a conundrum here.
Well, that's...
How can the law itself cure this situation?
No. I think we need a sort of civilizing process.
Right.
You know, for us to get a sort of acculturation to democratic tenets.
And norms.
See, the existence of the judiciary is a contemplation that there will always be conflict. There will always be misunderstanding. There will always be persons who want to abuse power, political power. So the problem, therefore, is where the institution that has been constitutionally set up to resolve crisis now becomes the creator of crisis. That's where it becomes a hopeless situation.
And it jumps into the arena.
So if you ask me, right. I am not the judge, neither am I the courts. It is and we have a hierarchy of court system where we find that even when you think that the court is not making the right orders, you proceed on appeal to the Court of Appeal. Right. As things stand with regards to the matters, the Court of Appeal has made a pronouncement that the status quo with regards to the contention as to the status of the members of the River State House of Assembly should be maintained.
Which is?
Just in that case,
that there are still members, the 27 PDP members,
and
that they're still members, even though they themselves said they had left the party.
So the position of the law is that status quo be maintained, which is also subject to a further interpretation. Which status quo? Is it as at the time they were members of the House of Assembly and the Amewele was still speaker, or as at the time when they were sacked, when they made the declaration that they were no longer members of the PDP? So that you see. That should not be left to any guesswork. The court, particularly the Court of Appeal, ought to have made that pronouncement. We expect that pronouncement to be made so that we know that there is peace, so that people can have this idea that you see, the court operates with a measure of integrity, and then they will submit to it. But what we have now is a contest of force, and that is exactly the opposite of what law is supposed to serve. Law is supposed to serve the function of certainty. That is, you know that this is the standard, and everybody subjects to it, knowing that it is impartial and that it does not support any other side against the other. But now we are talking about people not having monopolies of violence, and others threatening that they must remain, and while another group is threatening that they are coming with force to eject the council chairman. Whereas there are procedures for law. Where were these persons who are now brandishing arms, turning River State upside down when the House of Assembly was making law? However, I've observed, and because of looking at the records, that the House of Assembly, which was reinstated one way or the other through the intervention of the president, made that law following the valid process.
So now a political solution seems to have not worked. A legal solution, too, has not worked. Where does that leave River State?
You see, we have... we have the Attorney General of the Federation.
Yeah.
He has a constitutional responsibility to tell us at all times. He doesn't need to waste the time of going to the court. He's the one that will direct the president, advise the president, and possibly direct us as to what the position is as to the law at this time. Clearly, there ought not to be any form of breakdown of law and order in River State if the parties, particularly the governor. In this case, it's interesting that there's no much mention of the Minister of the Federal Capital Territory. It's about whether or not there is a valid law upon which certain the tenure of the chairman is extended, or the directive of the governor, which is clearly without any basis in law. You cannot say that the council should exist under the control of the head of administration.
Some are blaming the governor for not, organizing that. The
governor should actually apologize to the people of River State for that.
Okay. Frank Tietie will have to leave it there. Thank you very much. Lawyer and Arise Analyst.